Good morning to everyone and the dignitaries present on the dais. Welcome to the final rounds of the Moot Court competition of Sparkle 7.0. We have with us two teams who have fought all the way and arrived at the final rounds. Team code SMCC 22 will be the petitioners today, and team code SMCC 27 will be the respondents today. Over to the teams. Team's memorials.
Yeah.
This is his lordship. Of the score sheet lordship? Certainly, certainly. Yes. Yes, lordship. Yes, lordship. That won't be the final. Yes, lordship. We have the bench memorials, the Places of Worship Act,
Yes.
and the moot problem for your reference, lordship. Do I keep the bench memorials outside?
That's okay.
The act, I'll place it outside.
So are there any marks for the preparation of the memorials also?
Yes, lordship. The memorials have been separately valued, but not here. This is
Not
only
here.
for the audience.
Okay.
Erasers here. Pens here, lordship.
Greetings to the bench. Your Lordships, the Council seeks permission to address the bench collectively as your Lordships. Much obliged. Your Lordships, we are team code SMCC 22. We are here for the petitioners today. I am speaker number 1 and my co-counsel is speaker number 2. I shall be dealing with the issues 1 and 3, while my co-counsel will be dealing with the issues 2 and 4. If your Lordships are well versed with the facts of the case, may I move on to the arguments at once? Much obliged, your Lordships. Your Lordships, the first issue in front of us...
Can you very succinctly narrate the facts of the case?
Of course, your Lordship. Your Lordship, the facts in front of us today are that Aryavatha is a multi-religious nation which is also secular in nature. Your Lordship, in the past, Aryavatha has been under the rule of the Mughal era and under the colonial rule. When it gained independence, it got its constitution too. Your Lordships, during these times, when it was under the rule of others, there were a lot of places of worships that were destroyed and converted into other religions. This has continued over the time, and after gaining independence, there was communal unrest, which led to loss of property and life due to such conversions. During this time, the Parliament enacted the Places of Worship Act 1991. Here, today, the petitioners are contending the fact that the Places of Worship Act is unconstitutional to their rights. If your Lordships are satisfied with the facts of the case, may I move on to the arguments? Much obliged, your Lordships. Your Lordships, the first issue in front of us today is whether sections 3 and 4 of the Places of Worship Act 1991 violate fundamental rights guaranteed under Articles 14, 15, 25, 26, and 29 of the Constitution of Aryavatha. Your Lordships, sections 3 and 4, to give you a brief on what they say, are section 3 of the Act states a bar of conversion on places of worship. This means that any place of worship cannot be converted to another place of worship of another religion or religious denomination. Whereas section 4 of sections violate the constitution, fundamental rights of the petitioners under Article 14 of law to all of its citizens. The Supreme Court, in the case of your Lordships.
When was the When was the constitution passed?
Your Lordship, the Places of Worship Act?
No, when was the constitution passed?
Your Lordship, in the 1950.
1950.
Yes, Your Lordship.
When was the act passed?
1991.
1991.
1991, yes, Your Lordship.
Okay. So when did you file this case?
Your Lordship, this case was filed currently,
When?
like this time, 2026, Your Lordship.
2026.
Yes, Your Lordship.
So what were you doing all this time?
Your Lordship, first of all, there has been a bar on jurisdiction of courts, Your Lordship, under this act. And there is also an exception set by this court, by this act, in section 5 of the act, which was given only to the Suraiya Masjid. Your Lordship, due to this, cases were not maintainable in front of the courts.
So you are not answering my question, counsel. My question is, you filed in 2026. That is,
Yes.
how many years after? 35 years.
Yes, Your Lordship.
What were you doing for 35 years?
Your Lordship, there was no clarity about the act and what it entailed. But when the case was decided for the exception set, it gave the clarity on what the act was supposed to constitute and how
What's your
it was
motive? What's your motive?
to come to the court. Your Lordship, we find that these two sections are unconstitutional to our rights. They violate our rights and
So 35 years you have slept it, and you are coming with a
No, Your
different
Lordship.
motive.
No, Your Lordships, we haven't slept on our rights here. Your Lordships, there was
Do
an
you have a
exception.
political motive?
Sorry?
Do you have a political motive?
No, Your Lordships. Our
So
motive
then-
is only
How
influenced
many,
by
How many governments passed through?
several, Your Lordships.
So why?
Why, as in, why are we coming
The
today?
council can pass the stick. No, you can pass the stick. Because you're disturbing her. You can pass the stick. Yes. Why? Why
Yeah.
can't we think that you are politically motivated?
Your Lordships, none of our arguments are politically motivated in any form. We are arguing only on the basis of our rights, which we were given challenging the constitutionality of the act.
After 7 years?
Challenging the constitutionality of the act.
After 7 years?
Your Lordship, Your Lordship, this is... Your Lordship, cases have been filed before, and this is the first time that the Supreme Court has taken it up. So we have come here under Article 32.
Personally speaking, I proceed, but you have not answered my question.
Your Lordships, can I come back to your answer?
To clarify, my Lordship, what exactly Lordship is intending to ask you? So, for a period of 35 years,
Yes, Your
you
Lordship.
slept over your right. What was the cause of action to file the present case at 2026? That's what Lordship is asking. You have to clarify.
Yes, Your Lordship, as I have stated...
One more question is,
Yes, Your Lordship.
that you may be, that is politically motivated. All these times that your government was maybe there, that's why that you have kept quiet. And thereafter, now that some other government is there, that in that light you have filed. That's what the Lordship is asking you. You have to clarify why that you have slept over your rights for 35 years, 36 years. Fine.
Your Lordship, as I have stated, that when the Suraiya Masjid judgment came, we were given clarity over when and what kind of cases we can file, and they were, and Your Lordship, they were held to be non-maintainable. But after the 2019 judgment, we have filed this case, and it has been held maintainable, and that is why we are here in front of the court today.
Okay.
Much obliged, Your Lordships. Your Lordships, actually just... Your Lordship, Article 14 promises equality before law and equal protection of law to all the citizens of Aryavatha. Your Lordship, under this article, one of the judgments given, Dr. Saurabh Chaudhary and others versus Union of India and others, which I have provided you a copy of, there was the test of reasonable classification which was held. Your Lordships, under the doctrine of reasonable classification, there are two criteria that must be maintained. First is that there should be a rational nexus, and second, that there should be intelligible differentia. Your Lordship, first of all, Article 14 prohibits class legislation, but permits reasonable classification. But Your Lordship, here, first of all, this act becomes a class legislation because it is targeting not only the Paramdhara community, but it is also targeting the other religious denominations under this community and also other religions who have faced the destruction of their places of worship before 15th August 1947. Additionally, Your Lordships, by setting the date of 15th August 1947 as a freezing point, the Parliament has denied the people the right to come to court and have their concerns heard and adjudicated upon. Your Lordships, it is stated in the Act that to pass the test of permissible classification, two conditions must be fulfilled, namely, that the classification must be founded on an intelligible differentia, which distinguishes persons or things that are grouped together from others left out of the group. And secondly, that the differentia must have a rational relation to the object sought to be achieved by the statute in question. Your Lordships, the Act also gives an exemption to the Suraiya Masjid. Your Lordship, the Suraiya Masjid was one of the most disputed places of worship before the coming of this Act. And it has been the only one granted exemption. Additionally, Your Lordship, this exemption was only granted to this masjid, and the reason for the Act is to prevent communal violence. Your Lordship, in the statement of objects and reasons of the Act, the third, yes, Your Lordship.
1 minute. An individual himself can be a class by himself. That is the Supreme Court version.
Your Lordship,
Yes, there are so many decisions on that.
yes, Your Lordship, but there should be a nexus, rational nexus for choosing that person as different. But here, Your Lordship, there has...
What is the rational access which is not there in this?
Yes, Your Lordships,
No,
as I was...
in order to prevent the communal...
Yes, Your Lordship, but
yes,
as I
to
said...
maintain the communal harmony.
Your Lordship, as I
Yes.
stated, there has been an exemption given under this Act to the Suraiya Masjid. Your Lordship, there has been no reason provided, first of all, for this exemption. Secondly, Your Lordship, there were other cases pending in front of various courts about disputed places of worship before the coming of this Act. All of them were abated under Section 4, Subsection 2 of the same Act. Your Lordship, why was Suraiya Masjid given this exemption when it is one of the most disputed properties, places of worship, and is also one of the most contentious point due to which a lot of communal unrest occurred? So, Your Lordship, there has been no rational nexus behind this, and if anything, the exemption is going against the very reason for the Act. Your Lordship, another reason, 15th August 1947, Your Lordship, was a political shift from pre-independence era to post-independence era. This did not prove a shift from our past to the future. The past has continued to influence the people.
Are you challenging the Act now?
Your Lordship, I am challenging, currently under this issue, I am challenging Section 3 and 4.
No, are you challenging this Places of Worship Act?
Your Lordship, yes,
So
because...
you are challenging that?
Yes, Your Lordship, because Section 3 and 4,
So
the
you are
Act is
saying
on...
that this is inconsistent to the Constitution?
Yes, Your
Is that
Lordship.
you are saying?
Yes.
So can we take up that you are challenging the enactment as at today or as it was passed?
Your Lordship, it has not been amended in any form. So the Act has remained...
No, this was passed in 1991.
91, yes, Your Lordship.
Correct?
Yes.
So you are challenging from the root of it or you are challenging as per today?
Your Lordship, both.
So then
Your Lordship...
what are the consequences?
sorry, Your Lordship, can
What
you
will be the
repeat?
consequences? What will happen?
Yes, Your Lordship.
But the things were performed from 1991 to 2026.
Your,
Who is going to take responsibility?
Your Lordship, there was the only influence that this Act had was the fact that people were not allowed to file court cases in the court. Due to this, a plethora of cases have not been heard by the court and been adjudicated upon, which is of course against the rights of the people to have their case heard and be adjudicated upon. Additionally, Your Lordship, due to this, there has been a delay in hearing the cases themselves. And no cases can have been filed. So that is why even from the root till today, we are asking for our right to come and file those cases. Your Lordship, additionally, the date of 15th August 1947, it was just a political shift. It was not freedom from the past and it was only the freedom from the colonial rule. It also meant freedom in the future.
How are you going to connect to Article 29?
Okay. Your Lordship, Article 29 promises cultural rights to the people of Aryavata. Yes, Your Lordship. So, Lordship, places of worship historically have been not just a place where worship is given, but they have also been centers of art, science, and education. They have been where communities have grown and developed. By the destruction of these places of worship, the communities have been put on a back step, due to which they have not been able to exercise their cultural rights as well. Your Lordship, places of worship were also inhabited by Pandits, who were the most educated class of the Paramdhara community. They were also the ones who imparted this knowledge on the people. By the loss, by the destruction of the places of worship, there was also a loss of life of the people who inhabited it, which has led to the loss of knowledge. Additionally, Your Lordship, places of worship were not the only places that were destroyed during pre-constitutional era. There has been places of education such as universities that have also been burned down. This has led to a very suppression of the Paramdhara community in the past, and it has also made sure that they could not develop at the rate they might have if they had these places given to them. Continuing, Your Lordship.
So you're coming under the violation of fundamental rights.
Yes, Your Lordship.
So it started from the beginning.
I should start it from the...
No. Go ahead.
Oh, okay.
You should have aimed at the beginning
Okay.
for fundamental rights. Okay, go ahead.
Your Lordship. Your Lordship, Article 15 states that there shall be no discrimination on the basis of religion in Aryavatha. But this act goes contrary to it. Your Lordship, before Aryavatha gained independence, it was against under the Mughal rule and the rule of the Britishers. During this time, there has been records of 4,000 to 60,000 temples being destroyed. Your Lordship, while there are no clear records, the records that we have found have not been able to give us a concrete number, but they have stated that the range is in between this. Your Lordship, these were historical injustices that were committed to the people of Aryavatha. Your Lordship, in Navtej Singh Johar versus Union of India, it was held by this court that historical injustices must be corrected, and the Constitution was made to make sure that they do not occur again. Your Lordship, to quote paragraph 155, the ability of a society to acknowledge the injustices which it has perpetuated is a mark of its evolution. In the process of remedying wrongs under a regime of constitutional remedies, recrimination gives way to restitution. Diatribes pave the way for dialogue, and healing replaces the hate of a community. For those who have been oppressed, justice under a regime committed to human freedom has the power to transform lives. In addressing the causes of oppression and injustice, society transforms itself. The Constitution has within it the ability to produce a social catharsis. The importance of this case lies in telling us that the reverberations of how we address social conflict in our times will travel far beyond the narrow allies in which they were explored. Your Lordship, this states that the Constitution and the judiciary both work to make sure that historical injustices are corrected and not covered. Additionally, Your Lordship, freezing the date to 15th August 1947 takes away the people's right to come to court and also makes sure that the Parliament is validating the historical injustices that were suffered by the people. Your Lordship, another thing, in the case of Dr. M. Ismail Farooqi versus Union of India, it was held that two observations were made by the court, and in those observations it was held, firstly, that the protection under Article 25 and 26 is to religious practice which forms as an essential and integral part of the religion. A practice may be religious practice, but not an essential and integral part of that religion. While offer of prayer or worship is a religious practice, its offering at every location where such prayers can be offered would not be an essential or integral part of such religious practice unless the place has a particular significance for that religion so as to form an essential or integral part thereof. Places of worship of any religion having particular significance for that religion to make it essential or integral part of the religion stand on a different footing and have to be treated differently and then reverently. Your Lordships, there have been cases where prominent temples have been lost to the Paramdhara community due to historical injustices. For example, the Gyanvapi Masjid today stands on what was firstly the Kashi Vishwanath temple, which is one of the 12 Jyotirlings that has a very prominent part of the Paramdhara community. Another example, Your Lordship, is that the Shahi Idgah Masjid stands on what was the Krishna Janmabhoomi. And Lord Krishna again is a very important figure in the Paramdhara community. Your Lordship, by making sure that these cases cannot be adjudicated upon by the court, the Parliament is violating our right under Article 25, 26 and 29.
Who is the Parliament?
Your Lordship, the one who passed the act.
Who is the Parliament? Who is in the Parliament?
Your Lordship, the Parliament has changed from
No,
when the
who
act...
is the Parliament? Who is in the Parliament?
Your Lordship, the people who were government and the opposition parties and who were elected by the people.
So you elected. It's your representative. Your
Yes,
governor.
Your Lordship, but...
It's your people, your representative passed the law.
Yes, Your Lordship.
So why are you blaming us?
Your Lordship, I am not blaming the judiciary for anything. Your Lordship, I am stating here that while we might have voted for the Parliament, we also have a right to come and address...
Who passed the act?
Your Lordship,
There is a Parliament, there was a party,
Yes,
passed
Your
the
Lordship.
act.
Yes, Your
Did
Lordship.
you re-elect it? You elected them.
Your Lordship...
Did you re-elect them? Yes, you
Yes,
re-elected them.
Yes, Your
So
Lordship.
you approved their acts.
Your Lordship, that is not how... Your Lordship, if I may answer...
You take 2 minutes.
The time taken is given.
Much obliged, Your Lordship. Your Lordship, first of all, that is not how the Parliament works. We, as citizens, even if we have elected the Parliament that stands in power today, have the right to come and question their actions. That is what it means to be a democratic country, which allows us to have the freedom to make our voice be heard and have our issues be adjudicated upon by the judiciary. Additionally, Your Lordship, there's separation of powers which allows the judiciary to make sure that no violations have occurred, especially of the fundamental rights, by the Parliament due to arbitrary actions. If Your Lordship is satisfied with the answer, may I move on to the next
If you're
issue?
challenging the constitutional validity
Yes, Your
of
Lordship.
certain sections
Yes, Your
of
Lordship.
the Places of Worship Act,
Yes, Your Lordship.
don't you think that the Places of Worship Act is intrinsically related to the obligation of a secular state? That's what the...
Your Lordship, while the issue will also be dealt with by my co-counsel, to tell you, Your Lordship, secularism means that the state has no religion. It means that all the religions are treated with equal respect and that every law applies to them equally. Your Lordship, here the Paramdhara community is at a disadvantage. As in one of the submissions that I have given to you, in the case of M. Ismail Faruqi, one of the observations made by the court, while it was for another act, it was on the basis of the Surhaiya Masjid only. And in that, it was that maintenance of a status quo as on 7th January 1993, which is also after the atrocities have occurred, confers a lesser right of worship for the Hindu devotees than in existence earlier for a long time till the demolition of the disputed structure. It does not therefore have the effect of conferring or granting to the Hindu community any further benefit thereby. The provision does not curtail the right of worship of the Muslim community in the disputed area, there having been de facto no exercise of the practice or worship since 1949. Your Lordship, this... Your Lordship, may I sum up this point and the issue 3 in 2 minutes?
How long do you want?
2 to 3 minutes, Your Lordships.
3 minutes granted.
Much obliged, Your Lordships. Your Lordships, as I stated, even, yes.
Okay. We try to not to interrupt you. Go ahead with for about another 3 minutes.
Okay, Your Lordship.
Your full time is given.
Thank you, Your Lordships. Your Lordships, as I was answering, Your Lordships, the Places of Worship Act makes sure that the Paramdhara community, which has suffered the loss of temples to a very large extent, cannot come to the court and have their matter adjudicated upon. Additionally, Your Lordship, this does not affect the Zaria community to the same extent and is actually detrimental to the right of worship of the Paramdhara community. Additionally, Your Lordship, the place of worship does not lose its significance just because it has been destroyed under the Paramdhara community. Your Lordship, the divinity still resides at that place, and it is actually sacrilegious if the deities are moved from that place to another place without proper due respect and process. Your Lordship, whereas this is not the same case for the Zaria community. In the Zaria community's Quran, in the, chapter 9, verse 108, it has been stated that Allah accepts worship only from pure land. And this does not fall under here. Your Lordship, the masjids which are in dispute today have been built on disputed land. They are not pure lands, and the worship that is given there is not even accepted by their own gods. Additionally, Your Lordship.
I'll put you one question.
Yes, Your Lordship.
So we will direct the government to include this masjid and this temple also in that particular act, so that your grievance is over.
Your Lordship, which temple?
No, that this has been excluded. So that is your grievance.
Yes, Your Lordship.
No, if in this particular act, that if you include this particular religious institution also, banning,
yes. Your Lordship, it is
you
not.
are satisfied.
Your
Your
Lordship,
rights
this
are protected.
Your Lordship, this is just an example I'm giving. As I stated,
No. You are harping upon that particular point, that the reasonable classification is not there, this has been separated and all this.
Yes, Your
That
Lordship.
it is the major argument you are doing.
Yes,
so
Your
here,
Lordship.
that we will tell the government that you include that particular, that is a temple and masjid.
Your Lordship,
And that is also restrained. Yes.
Your Lordship,
you are
it is not
satisfied.
only about the
No,
temples
your
and
grievance
masjids.
is that it has been excluded. That's why that you are a grievance. What is your right
Your
which has been
Lordship,
affected?
Your Lordship, our right to come to court and have our cases adjudicated upon has been affected. Our right to ask for our
But
disputed
you are not
property.
concentrating on that. That is harping upon that reasonable classification is not there and all. So this masjid and temple. No. You are
yes,
concentrating
yes,
on that.
Your Lordship, as I
What
stated,
is your right?
Your Lordship,
Basically, that fundamental right,
Yes.
if it has been affected, so under Article 32 or 226, that the court can exercise.
Yes, Your
What
Lordship.
is the major right which has been affected to you?
Yes, Your Lordship, as I stated, Article 14, additionally Article 15, because this is discriminatory against not only the Paramdhara religion, but other religions who might have lost their places of worship before 15th August 1947. Your Lordship, if more.
Okay, 2 minutes.
Much obliged, Your Lordships. Your Lordship, additionally, Articles 25, 26, which grant us religious rights under the Constitution, have also been affected because under those rights, Your Lordship, we also have the right to manage our properties which are influenced by religion. At the same time, we have the right to come to court if there is a dispute over those said properties. Additionally, Your Lordship, Article 29 has also been affected because it grants us our cultural rights. And by the destruction of these historical places of worship, our culture has also been affected. So, Your Lordship, these are the articles that are being violated by this act, and why we are seeking the court to make sure that our rights are returned to us. If your lordship permits, may I move on to issue number 3? Much obliged, your lordships. Your lordship, issue number 3 states, does the act perpetuate historical injustices? The petition argues that freezing the status of religious sites as of August 15, 1947 disregards historical wrongs suffered by various communities. Your lordship, as I have stated even earlier, the communities have been affected for years, your lordship. We have been fighting for our places of worship back from the time they were destroyed. But this was the first time that we were granted a country that not only has the rule of law, but also has judicial review in its basic structure of the constitution, which had allowed us to have our matter heard. Your lordship, we are not asking for them back without providing evidence. We are here asking for the rule of law to be followed and the process that the law itself has set to be adjudicated upon. We are ready to provide the evidences and we are ready to go through the whole process. But that right has been taken away from us by this act. Additionally, your lordship, the cause of action is continuative in nature in these cases. Just because the land was, the place of worship was destroyed in the past, it does not mean that the hurt it caused and is currently causing has diminished. Your lordship, every single movement, your lordship, if you would just let me conclude the issue. Much
Yes,
obliged, your lordship. Your lordship, the structures that now stand on the places of worship that were taken away from us are also a symbol of the oppression we had faced, the destruction we went through, and the loss of life and property that we had to endure. Your lordship, this is the first movement when Aryavata gained its independence. The people were promised a nation who will hear their concerns and would let a proper authority adjudicate upon them. By taking this right away, the act is not only being unconstitutional, but is taking away the basic rights that even the preamble and the constitution as a whole offer. Your lordship, the people of the Paramdhara community and other affected communities are not asking here that please just give us the place of worship back without even hearing the other side. Here we are asking for a proper adjudication by having both the sides heard, by following the rule of law. Your lordship, reasonable restrictions can be placed on religious sites, but they should be reasonable and they should be restrictions. There should not be a full, complete ban on hearing the cases. To conclude, your lordship, by freezing the religious character of sites without regard to the circumstances under which such character arose, and by barring judicial scrutiny altogether, the act transforms temporary historical outcomes into permanent constitutional realities. If your lordships are satisfied with the arguments raised, may I call my co-counsel to them? Much obliged, your lordships.
Greetings to the bench. The counsel acknowledges the gracious presence of the bench. However, for the sake of gravity of time, the counsel seeks permission to address the bench as my lords. Much obliged, my lords. My lords, if there are no queries with the submissions made by my learned co-counsel, the counsel seeks permission to move in with the second issue. My lords, the second issue deals with whether the Act denies access to judicial remedies which are protected under Article 32 and 226, my lords. My lords, this Act denies direct access to judicial remedies that are guaranteed under Article 32 and 226 of the Constitution, my lords. My lords, the Constitution of Aryavarta is premised upon the rule of law, wherein the rights are rendered meaningful only through the availability of effective remedies before independent constitutional courts, my lords. My lords, by imposing a blanket bar on the courts from entertaining claims relating to the religious characters of places of worship and by mandating the abatement of pending proceedings, the impugned act effectively extinguishes the jurisdiction of this honorable court and the high courts over an entire class of disputes. My lords, such legislative exclusions not only undermine the enforceability of fundamental rights, but also violate the basic structure of the Constitution, of which the judicial review and access to justice form an integral part. My lords, I'll be giving my submissions in twofold arguments. Firstly, dealing with how judicial review forms a basic part, and second, dealing with violation of fundamental rights, my lords. My lords, coming to the first fold of the argument, my lords, Article 32 has been described as the heart and soul of the Constitution, and it has been termed a part of the basic structure doctrine, my lords. Along with that, my lords, Article 226 confers the same powers upon the High Court to enforce the fundamental rights and legal rights as held in the case of L. Chandrakumar versus Union of India, my lords. My lords, this act, through sections 3, 4, and 5, creates an absolute prohibition on the courts for entertaining any suit, appeal, or proceedings seeking to alter the religious character of a place of worship, my lords. My lords, further, it mandates that all the pending proceedings shall stand abated, irrespective of the stage of litigation or the merits of the claim, my lords. My lords, this results...
Mr. Counsel,
Yes, ma'am.
before that is, you read Article 32, Clause 1 and 4 together.
My lords, Article 32, Clause 1 and 4, my lords.
4. So that is problem is over there.
Yes, my lords.
The right guaranteed by this article
Yes.
to move this code. So here it says shall not be suspended except as otherwise provided for by this constitution.
Yes, my lords.
Constitution is not that is prohibiting.
Yes, my lords.
So that's why that every right is there for you.
My lords, we are
No,
not...
no.
Rightly.
It has a guaranteed under the constitution itself.
Indeed, my lords.
Yes,
My lords, we are here not contending...
you know,
my lords.
you see whether the constitution prevails or an act prevails.
My lords, the constitution prevails.
Then
Indeed, my lords. My lords, our contention here is that under Article 32 and 226, which guarantees judicial review. My lords, through this act, there is
No,
an
no.
exception.
Your right was there,
Yes, my
but you
lords.
have approached belatedly to this court.
My lords, we have...
No. That right was in existence.
Yes, my lord.
You have come belatedly to this court. That is your fault.
My lords,
No.
may I answer to that, my
Though
lords?
the act has been passed in 1991, so here you slept over your rights, then you have, that is awoken, no, I am having a right under Article 32 and now that you have come.
May I answer to
That right has not been restricted.
Right.
If an amendment has been brought to the constitution,
Yes.
then you are justified.
Rightly stated, my lords. My lords, in 1991, when the act was passed, there were massive uproars
Now,
in the
why that
country.
we are concentrating on that, on the basis of limitation itself, the writ petition is liable to be dismissed.
My lords, rightly stated, my lords, but the answer
You
to...
cannot invoke the right as and when you, that is,
But my lords, after the 2019 judgment of this Honorable Supreme Court in the Suraiya Masjid dispute, after that the petition was filed, and today, my lords, it was filed in 2023, and today it has come for final hearing, my lords. Apart from that, my lords, from 1991, there has been massive uproars in the country. A lot of petitions have been filed before this Honorable Court. My lords, even in the proposition it has been given that along with different petitions filed, this Honorable Court has has combined all the petitions and set for final hearing today, my lords. My lords, continuing, my lords. My lords, this act through sections 3, 4, and 5 creates an absolute prohibition on the court from examining any suit, appeal, or proceedings seeking to alter the religious character of a place of worship, my lords. And my lords, this result of extinguishment of existing legal claims, prohibition on future judicial remedies, and denial of adjudication on merits such as legislative scheme goes beyond the procedural regulation and amounts to substantive denial of justice, my lords. My lords, under Section 9 of the Civil Procedure Code, it gives the civil courts the power to hear any sort of civil cases except the ones that are barred by an act, my lords. My lords, in the case of Dhulabhai versus State of Madhya Pradesh, in page 19 of the memorial for the petitioners, my lord,
Yes.
my lord, this honorable court had held that exclusion of jurisdiction of civil courts must be strictly construed, and such exclusion cannot be readily inferred unless explicitly justified. My lords, even where the jurisdiction is excluded, adequate alternative remedies must exist, failing which the bar become unconstitutional. And my lords, in the present case, the Act provides no alternative forum or remedy, thereby completely extinguishes our access to justice. My lords, we have approached this Honorable Court under Article 32 as of we have filed a PI. My lords, we are not denying that we cannot access, we have challenged the constitutionality of that. We are not denying that the Act prohibits us to do so because that is a constitutional right. My lords, the point that we are contending here is that we cannot challenge any disputed property before the freezing date of 15th of August 1947, that violates a fundamental right, my lords. Because, my lords, the freezing date that has been set by this act does not fall under the category and does not have a reasonable classification under Article 14, which I'll be giving in my future, in my further arguments, my lords. So, my lords, coming to the second fold of the argument, dealing with the violation of fundamental rights. My lords, firstly, my lords, dealing with Article 14. My lords, the indigenous communities have been at the receiving end of injustice from the medieval and the colonial era, my lords. My lords, well-documented historical events highlight the brutal and unjust trampling down of indigenous faith systems and their places of worship.
You are not an indigenous community, you are the majority community.
My lords, we are the majority community, but at the same time, we have been we are indigenous to the country, my lords. We are indigenous to the country of Aryavata.
You have to categorize, because the reason is the moment you say indigenous, then you comes into the different column of the constitution. The constitution provides specific safeguards for you. So since being a majority, how do you claim yourself as
My lords,
minority?
My lords, we are nowhere claiming that we are the minority here, my lords. Only thing we are claiming is that we have been the indigenous community for centuries. From centuries, my lords, from the Mughal era to the colonial era, our rights have not been respected, my lords. In the Mughal era, my lords, a lot of our temples, not only our religion but different religions, the place of worship has been destroyed, and their place of worship has been constructed on that, my lords. We had no rights then. When, my lords, the colonial era started, we couldn't approach the court for seeking the violation of our fundamental rights, my lords. And, my lords, now, when after we got independence, my lords, the people of Paramdhara and different religions, they had a hope that now they can file a case before this honorable court, and with the process of law, the religious dispute that has been going on, the place of worship that their faith relies on, they will be getting justice for that. But, my lords, in 1991, when this act was enacted, this creates this snatched away the very fundamental right that they believed that they will get after the independence, my lords. Then, my lords, we also submit that the acts need to be tested from the cornerstone of Article 13, Clause 2, which establishes the unconstitutionality of the legislation if it is violative of the fundamental rights, my lords. My lords, this legislation takes away the previously available rights through its enactment, and its actions are considered to be unconstitutional and in violation to the basic structure doctrine, my lords. My lords, as held in the judgment of Anita Khuswan versus Pushpap Sudan, my lords, in this case, the Supreme Court had held that the citizens' inability to access courts or any other adjudicatory mechanism provided for the determination of rights and obligation is bound to result in the denial of guarantee contained in Article 14, both concerning equality before law as well as equal protection of law. At the same time, my lords, Article 21 has also been held as being violated when access to justice is being denied. My lords, here access to justice has been defined as the state must provide an effective adjudicatory mechanism. My lords, via this act, no adjudicatory mechanism has been provided, my lord. Thereby, this denies access to justice, my lord, and is in violation of Article 14 and 21. Along with that, my lords, in the case of Menaka Gandhi versus Union of India, this court had laid the direct...
How does 21 comes here?
My lords?
How are you going to bring 21 here?
My lords, Article 21 deals with right to life and dignity.
Right to life?
Yes, my lords. My lords,
So how do you
via
bring
this...
right to life here?
My lords, via this judgment that I have cited, my lords, we are the people of Paramdhara faith and different religions are not able to get the access to justice here, my lords, which is denied here. And in this case, it was held that along with Article 14, Article 21 is also violated, my lords, because the justice, indeed, as it is held, my lords, in the second page, my lords, the second para, 7th line, my lords. No hesitation in holding that access to justice is indeed a facet of right to life guaranteed under Article 21.
Have you pleaded 21 in your petition?
My lords, the petition, the issues that are set by this honorable court, they have not included 21, my lords. But
So,
for this,
when it's not scheduled, how are you going to get in?
my lords, for this particular issue, I'm just trying to get a broader view of how different fundamental
Because
rights are being.
Article 21 is very widely interpreted.
Rightly so.
Are you trying to get shelter out of a different article? Then you
No, my lords, we are
brief.
just... My lords, we are claiming here how from Article 14, 21, 25, 27, 29, all these rights are being violated.
21 is not claimed.
My
Have you?
My lords, we have, like, as per the issues set by this honorable court, 21 is not mentioned, my lords. That is why, my lords, for the first and for the issues that were dealt by my learned co-counsel, 21 was not mentioned. But, my lords, when I'm mentioning about the violation under Article 32 and 226, I'm also establishing the fact that different fundamental rights are being infringed, including Article 21, my lords.
So you're going beyond the brief.
My lords?
You're going beyond the petition.
My lords, we are just claiming that Article 21 is violated, but in our prayers, we have nowhere mentioned that Article 21 is in violation because it was the issue set by this honorable court.
And how do you justify that Article 21 is violated?
My lords, as said by this very judgment, my lords, when access to justice is denied, in the present case, my lords, if I want to file a case of a religious structure that existed and another religious structure was built over there before the independence, that is 1947, my lords, I cannot come to this honorable court and seek justice, my lords, because this act sets a freezing date that petitions before that the place of worship in contention before 15th of August 1947 cannot be challenged in any court of law. So, my lords, this denies an access to justice to us, my lords, because there is no adjudicatory mechanism or any other forum provided, my lords. Because, my lords, if the respondents here or the government here seek that if allowing this petition would seek to thousands of cases being filed, my lords, then, my lords, this honorable court as the government are very well aware that tribunals or other such adjudicatory forums can be provided. My lords, here no such forum is provided. Our total right has been denied, my lords.
No, providing another forum is nothing but providing another court itself.
Right, yes, my lords.
So same litigation, same forum, something that which we are asking is alternatively another that is forum. That's
Indeed,
all.
my lords. My lords, we are here, my lords,
So
as
what
mentioned.
what makes the difference between the court and that tribunal or some other forum?
My lords, no, indeed, my lords.
Adjudicatory methods are one and the same.
Indeed, my lords.
Then
Indeed, my lords, here, my lords, our contention is only that we want that a process of law should be followed for hearing that what our rights have been
no, what
infringed.
is the purpose of the act? So here, so many litigations are pending before the court. To put an end to that, this particular act has been
My
passed.
lords, we are just contending
No,
that
no,
if
you are
the
asking for that is creating another forum.
apologies if that
Tribunal.
was said. No, my lords, our contention is that if the respondents
How
here,
how that you justify it?
my lords, justifying that an alternative remedy, my lords.
Yeah.
My lords, because my lords, if the respondents here, if the government, if they seek that if allowing cases before
Alternative remedy is given, whether your rights are going to be protected.
yes, my lords, my lords, at least if an alternative remedy is given, at least there will be a place where we can come, where our rights will be adjudicated, my lords. My lords, even
The very purpose of the act itself fails.
my lords.
Very purpose of the act itself fails.
Yes, my lords, we are contending that this act is unconstitutional, my lords.
No, that is the main.
Yes, my lords.
Yes.
My lords, even after all that we plead here is that, my lords, that we want a mega forum whereby our injustice can be heard. Even after hearing all the arguments and the submission, if this honorable court or any other forum feels that what we are pleading does not suffice, my lords, we will be okay with that, my lords. But here we have not been given a chance to present our argument, my lords, and that right has been snatched away by the government, my lords. My lords, as stated in the case of Menaka Gandhi versus Union of India, my lords, it had laid down the direct effect test, my lords. My lords, in this test, it had declared that this test declared that the inevitable outcome and not the objective of the legislation shall be tested when judging the breach of a fundamental right. My lords, taking the same analogy here, my lords, the direct effect of this act is the violation of the fundamental rights of people at large. Although the objective of the act may be to promote public harmony, my lords, but here the direct effect, that is the violation of the fundamental right, is being seen, my lords, which is a direct, which, my lords, is a direct breach of the fundamental rights. Lastly, my lords, in the case of Indira Gandhi versus Raj Narayan, this honorable court struck down a constitutional amendment that insulated the electoral disputes from judicial scrutiny, and the court held that free and fair adjudication is an essential component of the basic structure, my lords. My lords, applying the same reasoning here, the insulation of the religious disputes from courts amounts to a denial of the constitutional adjudication, my lords. Because, my lords, the government is taking away the right of the people, of the citizens, to adjudicate their claims, my lords. And this honorable court has held in this case that this is an essential feature of the basic structure, my lords. Coming to the second fold of argument, my lords, contending the violation under Article 20. Significance of the temples, my lords. My lords, the temples were destroyed about in 1600 or 1700s, my lords. This act was passed in 1991. My lords, what is the logical connection in choosing 15th of August 1947 as the freezing date, my lords, does not clarify the rational nexus, which is an essential under Article 14, my lords. Moving on, my lords, if my lords are pleased with this issue, can I move on?
According to you, what should have been the date, if not 15th August?
My lords, we contend that there should be no date as a freezing date, my lords, because as mentioned in my earlier submissions, my lords, the people of Paramdhara and different religious faiths, they have been facing persecution for centuries, my lords, and after independence, it was the responsibility of the state to act as a neutral body to adjudicate these claims, my lords. To act as, yes, my lords.
Did they have jurisdiction? or do we have jurisdiction?
Uh,
Because that belongs to different state or the countries at that time.
Rightly stated, my lords, but my lords, constitution is, my lords, is not a forward-looking document, because my lord, constitution also have retrospective effect, my lords. At the same time, my lord, we are contending the injustice or the infringement of the basic fundamental rights that were infringed in the past, my lords. That has to be restored, my lords, because here, my lords, 4,000 temples were destroyed. Can I continue, my lords? My lords, 4,000 temples were destroyed, my lords, from 1600. My lords, the people of Paramthara and different faiths did not have any sort of claim or any sort of adjudicatory process, my lords. And my lords, when the constitution came in inception, when our country came in inception, my lords, that right was snatched away by the passing of this very act, my lords. My lords, moving in.
I asked your co-counsel also
Yes, my lords.
that the Places of Worship Act is intrinsically related to the obligation of a secular state.
Rightly so.
Then on that context, what do you want to say?
My lords, secularism, as my co-counsel says, secularism means that there should be no state religion. State should act as a neutral party here, my lords. So, my lords, if the state is acting as a neutral party, we are not asking the state to come support this particular religion. All that we are asking for the state and the judiciary here is that there should be a neutral forum whereby our rights, what were infringed, can be heard. And the judiciary, as we believe, is a very neutral party here. It can adjudicate these claims. It can hear from both the sides.
Are you prohibited from professing any particular religion?
My lords, I couldn't.
Are you prohibited from professing any particular religion?
No, my lords, I'm not.
You are
We are not. Yes, my lords.
It's only the right to agitate that has been, according to you.
My lord, right to profess religion, as my lords, as submitted in the Ismail Faruqi case, my lord, that my learned co-counsel had submitted. In that, my lords, places of worship, especially the important places of worship, also like if we are denied access to the important places of worship, that also acts as a denial of fundamental right under Article 25. Here, my lords, apart from the Suraiya Masjid, the Varanasi temple and the Mathura temple, all these three hold a very significant value to the faiths of the people of Paramthara religion, my lords. So, two of them are the birthplace of deities. One of them is one of the 12 Jyotirlingas, my lords. So, my lords, these hold a very significant value to the faith and culture of the people, and denying access to that particular piece of land is a denial of the fundamental right, my lords. My lords, moving in with the fourth issue, my lords.
You read section 3
of the Act, my lords?
Yeah.
My lords, section 3, bar of conversion of place of worship.
That professing your own religion as it is, that there is no bar.
Yes, my lords.
What has been prohibited is convert any place of worship of any religion.
Yes, my lords.
Now that you cannot.
But
What has happened in the history, it is a history. What do you mean by history? It has happened something.
my lords, it has happened.
That
Yes, my
you
lords.
want to rewrite the history.
My
By
lord-
virtue of, that you see,
Yes, my lord.
what is history?
Something that has already occurred.
What has happened?
Yes, my lords.
Eventually, whatever happened, happened.
Indeed, my lords.
So it is a history.
Yes, my lords.
One of the history is that some temples have been destroyed and everything is, that you have to accept as it is.
My lords, but
No,
one-
you want to rebuild the history by virtue of exercising your right.
my lords, but
So whether
the-
it can be permitted.
But my lords, the temples that we are talking about here hold a very significant value to the culture and faith of the people, my lords. Now, my lords, as Aryavarta, my lords, the world knows that
That right has not been curtailed here.
My lords,
That right has not been curtailed. What has been curtailed is, so no person shall convert any place.
yes, my lords.
Now, as it is, whatever is there, it is there.
Yes, my lords.
So if you want to go and worship there, you can worship.
But my lord, that
No,
play,
how that your right is going to be affected by that?
My lords,
Like-
because
No,
the-
no, everybody,
Yes, my lords.
it will be, that is continuing right.
Yes,
So somebody comes and shows the history, no, earlier this particular temple was not there, masjid was there.
Yes, my
And again, that somebody comes and that this temple was there, masjid was not there.
Yes, my lords.
So here, that how that you can resolve this particular problem?
My lords, in the Ayodhya judgment of 2019, this honorable court issued ensured that on the disputed piece of land, the temple should be built, and they gave another piece of land for the masjid to be built. Similar stance can be taken by the authorities here. My lords, we are not contending that the temple or whatever the structure is should be destroyed and the structure was there that should be constructed. All that we are asking is that a process of law that we shall be able to tell our claims. If, my lords, after hearing to the both the sides, after hearing to the both the side, this honorable court feels that what we are demanding is too much, this honorable we will be obliged to order the whatever the honorable court feels, my lords. But, my lords, here we are denied the basic right to access to the court, my lords. That is our only contention. At the same time, my lords, when you mentioned about a history, my lords, history is something.
Access to the place is not restricted by virtue of this act.
My lords.
Nowhere it has restricted.
My lords, the access is not denied, but the structure there does not belong to my religion, my lords. Now, my lords, I cannot go and pray in a mosque, my lords. I cannot go and pray in front of Jesus Christ, my lords, because that is not a part of the religion, my lords. At the same time, my lords, as you mentioned about history.
No. On the top of it, if it is a church or if it
Yes,
is
my
a masjid,
Yes, my
so if Jyotirlinga is there inside, so you go inside and pray your.
My lords,
that
it is not.
Jyotirlinga
My lords,
only.
my lords,
So
it
who
is
prevented you?
My lords, the very structure that is there, earlier another structure was that which has been destroyed.
Structure
Now, my
is
lords,
out. No. What is religious feeling?
my lords,
It is internal.
my lords, it is my lords,
Yes.
internal. But, my lords, the place, the
Structure is different.
my lords, but the structure that we are talking about holds a very significance to our religion, my lords. Because, my lords, even if me as a people,
If I go to a masjid and say Shiva, 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 nobody prohibits me.
but, my lords, nobody. My lords, nobody prohibits you, but, my lords, my faith from what I believe has been is an injustice here, my lords, because no citizen can be expected to go to a place of worship of another religion and pray for the God of their religion, my lords. That is an absolute injustice towards them, my lords. And, my lords, here we are not claiming any arbitrary right. Here, my lords, the structure existed there. We are asking for an adjudicatory mechanism, my lords.
Religious feeling is an internal aspect.
My lords, it is an internal aspect, my lords, but at the
You
same
should
time,
not show to everybody.
my lords, now that is, my lords, we shall not show that to anyone, my lords, but, my lords, the constitution does not nowhere tell that we cannot profess our religion or propagate our religion, my lords. We cannot force someone that follow this religion,
Yes,
but we
yes,
cannot,
yes,
much
okay.
obliged. My lords, moving with the last issue, my lords.
Yes.
My lords, the last issue deals with whether this act conflicts with the secular fabric of the constitution by preventing the redressal of legitimate grievances. My lords, we contend that by barring judicial recourse and abetting pending legal proceedings, this act does not merely preserve peace, it institutionalizes historical wrongs and grants statutory permanence to acts of medieval aggression. My lords, this case compels this court to determine whether the parliament can oust the basic structure of judicial review to shield the archaeological truths from the light of law, and whether the promise of secularism under the constitution of Aryavatha include the right of a community to reclaim its deserted heritage. My lords, I shall be giving in a fourfold arguments. First, my lords, secularism constitutionally requires the existence of a neutral adjudicatory forum, and the judiciary performs this indispensable role. My lords, in a plural society, disputes concerning the religious rights are inevitable, my lords, and the constitution does not mandate their suppression, but their resolution through impartial legal processes, my lords. However, my lords, by barring the courts from entertaining claims and mandating the abatement of pending proceeding, the act removes this neutral forum altogether, my lords. My lords, this strikes at the operational core of secularism. My lords, a secular constitution cannot promise equal respect among religions while simultaneously denying equal access to adjudication, my lords. As such, denial renders this denial renders the neutrality as an illusion, my lords. Secondly, my lords, this impugned act replaces the judicial determination with legislative finality, which is impermissible under the constitutional scheme. My lords, the constitution rests upon the adjudication through evidences, reasons, and judicial scrutiny, and not upon the legislative declaration of historical truth. My lords, in the case of Indira Gandhi versus Raj Narayan, this honorable court held that legislative predetermination of disputes violates the rule of law and separation of powers.
Wherever
My
you
lords,
mentioned in your written notes,
my lords, this
please refer to those.
apologies, my lords. My lords, this particular judgment is not in the memorial, my lords. I plead ignorance for not able to give a copy of the compendium for the same, my lords. Apologies for the same, my lords. My lords, this honorable court had held in that case that legislative predetermination of dispute violates the rule of law and separation of powers. My lords, by freezing the religious character of all places of worship 15th of August 1947 and extinguishing the pending proceedings, Parliament has effectively foreclosed the judicial inquiry. My lords, courts are prevented from examining evidences, assessing competing claims, or predetermining legal entitlement. And my lords, such statutory closure undermines the very foundation of the rule of law of secularism, which requires the disputes be resolved through judicial processes, not buried under a legislative fiat, my lords. My lords, the third submission, my lords, this act destroys the secular neutrality through selective exemptions and fails the test of proportionality. My lords, the statute permits certain disputes to proceed while permanently barring all others, thereby introducing arbitrary and selective treatment. My lords, as held in one of the cases, my lords, such selective statutory protection without rational basis.
Which cases? Is it
My lords,
from
in the
AI?
case of Subramaniam Swamy versus CBI, my lords.
I thought it's from some AI.
No, my lords, actually, I couldn't give the compendium, my lords, so that is why I didn't cite the case. In the case of Subramaniam Swamy versus CBI, my lords, it was held that such selective statutory protection without rational basis violates equality, my lords. My lords, if adjudication is permissible in one instance, its denial in other becomes manifestly arbitrary, my lords. Furthermore, my lords, even assuming that preservation of public order is a legitimate aim, the means adopted must be proportionate to that, my lords. This act imposes a blanket, nationwide and permanent prohibition which is manifestly excessive here, my lords. My lords, less restrictive alternatives such as regulated adjudications, specialized forums, or evidentiary safeguards were available, my lords. And my lords, by choosing the total prohibition, the Parliament has adopted the least constitutionally compatible measure, thereby violating the constitutional morality and balance, my lords. In conclusion, my lords, it is submitted that the impugned act transforms secularism from a doctrine of equal justice and principled neutrality into one of the institutional avoidance and enforced silence. Its denial access to courts replaces the adjudication with legislative finality, perpetuates historical injustices, and introduces arbitrary classification. My lords, secularism under our constitution demands equal adjudicatory access, truthful examination of claims, and enforceable of rights, my lords. By failing on each of these counts, this act violates the basic structure of the Constitution and is therefore liable to be struck down as unconstitutional. If my lords have no queries for the submissions made, can I move in with the prayer, my lords? Much obliged. Wherefore, in light of the arguments advanced, cases and authorities cited, the counsel for the petitioners humbly request the Honorable Supreme Court of Aryavatha to declare that Sections 3 and 4 of the Places of Worship Act 1991 are unconstitutional and void, and being violative of the fundamental rights guaranteed under Article 14, 15, 25, 26, and 29 of the Constitution of Aryavatha. To declare that the impugned provisions are violative of Article 32 and 226 as they deny access to judicial remedies and undermine the basic structure of the Constitution, including the judicial review. To hold that the Act, by freezing the religious character of a place of worship as on 15th of August 1947, perpetuates historical injustices and is therefore unconstitutional. To declare that the Act is inconsistent with and violative of the secular fabric of the Constitution, which forms a part of the basic structure, and by preventing the redressal of legitimate grievances through judicial adjudication. Lastly, to strike down the impugned provision to the extent that they bar the courts from entertaining claims relating to the historical character of a place of worship, and pass any such appropriate order as the court may deem fit in the interest of equity, justice, and good conscience. We rest our case, my lord.
Greetings to the Honorable Bench. The Council is appearing before this Honorable Court in the matter of Arya Heritage Collective versus Union of Aryavarta on behalf of the Respondent. The Council seeks permission to address the bench collectively as your Lordships.
The
Much
first,
obliged, Your
first
Lords.
question is
Yes, Your Lord.
whether that you are addressing the bench or a single individual judge.
Your Lordship, the Council is addressing the bench.
Then why that you provide only one copy to the bench with regarding to the decisions?
Apologies for the same, Your Lords.
Hmm?
Apologies for the same, Your Lords.
And bench consists of 3. So you have to provide 3 copies.
Indeed, Your Lords, apologies for the same.
Huh?
Apologies for the same, Your Lords.
Apology will not rectify the defect. Hmm? How can we go through the decisions which you have quoted?
Your Lordships, for
We
the
are
sake...
not silent spectators.
Indeed, Your Lords, for
Yeah.
the sake of convenience of Your Lordships, whenever the Council will refer to a flag which is in the compendium,
You are not
the Council
arguing
might
before a
wait for a
lower
time
court.
for... Lords?
You are not arguing before a lower court.
Indeed, Your
You are
Lordships.
before the Supreme Court.
Indeed, Your Lordships.
You know the procedures.
Indeed, Your Lordships.
Then
Your
you are
Lord-
representing the state.
Indeed, Your
If
Lordships.
states is like that, how the general public can respect the courts?
Your Lordships, for the sake of convenience, the Council humbly begs your Lords that whenever the Council will refer to a flag which is in the compendium, the Council will wait for a few time for which the bench may go through the same, Your Lords. The Council will wait while the bench will go through the...
Proceed. Yes.
Apologies for the same, Your Lords. Your Lordships, the present matter raises 4 issues before us, Your Lords. The Council shall address the first and the third issue, while my co-counsel will be dealing with the second and the fourth issue, Your Lords. If Your Lordships are knowledge with the facts of the case, the Council seeks permission to proceed with the issues of the case, Your Lords.
Do you have any difference with the facts or you go with the facts?
The facts of the case are same, Your Lords, as provided
So
by
you
the
agree
Moot.
with the facts?
Lords?
You're not disputing the facts.
No, Your Lords.
Go ahead.
Much obliged, Your Lords. Your Lords, the first issue pertains to as to whether Section 3 and 4 of the Places of Worship Act violate Article 14, 15, 25, 26 and 29 of the Constitution. The Council humbly submits, Your Lords, that Section 3 and 4 of the Places of Worship Act are constitutionally valid and they do not violate Article 14 and 15 of the Constitution. The first contention of my learned counsel was that, Your Lordship, the cutoff date is arbitrary, Your Lordship. Your Lordship, the petitioners herein humbly contend that the selection of the cutoff date, which is 15th August 1947, is not violative of Article 14, Your Lords. The learned counsel's argument is fundamentally misconceived, Your Lords, as the present counsel's humble argument in this regard is that Your Lordships, this contention of my learned counsel that the cutoff date is arbitrary, Your Lords, shall be answered with the understanding of the essential criteria for a reasonable classification which is established by this honorable court, Your Lords. A classification is valid, Your Lords, if it is found on an intelligible differentia and if it bears a rational nexus with the object sought to be achieved, Your Lords. Herein, Your Lords, for the purpose of object, the object of the act is to prohibit conversion of any place of worship and to provide for the maintenance of the religious character of any place of worship, Your Lords. This date is chosen, Your Lords, as it marks a constitutionally significant moment and a shift from a colonial rule to a constitutional republic, Your Lords. It represents a constitutionally significant moment, Your Lords, marking independence and the beginning of a new legal order. If Your Lordships may kindly refer to flag number 9 and 10 of the compendium.
This time go against your time.
Your Lords?
The time we take go against your time.
Indeed, Your
Not
Lords.
them. Because it's your problem now.
We'll adjourn then.
Your Lords, even the respondent side wasn't provided with every copy of every case
But
they
at
have
least
cited.
they have given you the judgments which they were referring.
Only 2 cases, Your Lords, whereas multiple cases were cited by the
You
petitioner
have not
side.
raised.
Lords,
You have not raised your objection.
Lords, we were of the belief that, Your Lords, serving a copy in a moot court is not a mandatory practice, Your Lords. Apologies for the same, Your Lords. If your lordships may refer to flag number 9 and 10 of the compendium, your lords, this honorable court has recognized that, your lordship, this honorable court has recognized that independence that is 15th August 1947 marks a watershed moment that heals the wounds of the past, your lordship. Further, your lords, this honorable court has consistently recognized that the prescription of the cutoff date is well within the competence of the legislature, your lords. If your lordships may kindly refer to flag number 20 of the compendium, your lords. It has been held herein, your lords, that the legislature fixes a cutoff date by keeping in view the relevant circumstances before itself, your lords, and that a judicial interference is only warranted if such a cutoff date is blatantly arbitrary, your lords. Furthermore, your lords, the contention of my learned counsel was that Section 5 of the Act is arbitrary, your lords. The counsel humbly submits here, your lords, that Section 5
Was it historically considered before fixing the date on that said act?
Indeed, your lords, 15th
Where you
August.
have the evidence to say that you have historically considered? You could have seen a date of aggressive or date of aggression, or the date they invaded or they captured the place, or the date they have destroyed the place. Do you admit that this was built on a site which was worshipped by another religion?
Pardon, your lords?
Do you admit the fact that the present site had been built on a religious site of the Aryavada?
Your lordships,
Do you admit or you don't admit?
Your lordships, the humble contention of the council is that the council is not in the capacity to give the decision that if a particular site is built on another particular site, your lords. These are facts of every case, your lords.
Correct. The present matter before the court has a certain archaeological value
Indeed, your
by
lords.
your own institution.
Indeed, your lords.
ASI
Indeed.
says this is somewhere around about 2000 years old.
Indeed.
Am I correct?
Indeed, your lords.
The present site is somewhere about 600 or 700 years old.
Indeed, your lords.
So then, one above the other. So which gets the precedence?
Your lords, it should be considered that if not 15th August 1947, your lords, then what date is to be considered, which can be of a common consensus, will be a heavy dispute, your lords. Your lords, if it is contended by the petitioner that since the date of coming of the Zaria rulers on this land should be the cutoff date, your lords, the Buddhist community from this country, your lords, may rise and say that
Go back.
Yes, your lords.
Go back.
Exactly, your lords. Hence, your lords, an innumerable dispute may rise as to what previous date should be fixed, your lords. This honorable court has already recognized the importance of the date, which is 15th August 1947, your lords. Hence, it is fixed, your lords.
Was it a considered date? The question is, quote and unquote, considered date. Or just to save the neck or to save a political issue, date was fixed.
Your lordships, the same was not a political issue and the same date was not considered for any political connection, your lords. This was a considered date, your
Have
lords.
you all considered a borderline of this country?
Indeed,
Has the Aryavada considered certain borderlines of the country?
indeed, your lords.
So then, is it a political convenience or a population consideration or a popular consideration?
Your lords, it should be understood that the borders of this country, Aryavarta, were bifurcated on 15th August 1947 is an indisposable fact, your lords. However, your lords, the same contention has no connection with the present date, your lords, because, your lords, the present date which is fixed here is for the
This
purpose
was done
of...
in 1991. This was done in 1991,
Yes, your lords.
correct?
Yes.
Was there another dispute between 1947 to 1991 regarding a border?
No, your lords.
No?
No, your lords.
Isn't there a east and west divided of your neighboring country?
They are divided indeed, your lords.
They divided.
Yes.
So you were also part of it.
Indeed, your lords.
You were also part of it.
Indeed, your lords.
Then you know there is a political decision being taken. So it is not a considered or a feeling based or belief based decision being taken in this.
Your Lords, the council would reiterate the same contention, Your Lords, that for the purpose of a feeling-based contention, Your Lords, a cut-off date can go back to any amount of time, Your Lords, even prior to the advent of the Zaria rulers, Your
I
Lords.
agree with you, counsel, but the argument they are put forwarding is this date is an arbitrary date. So therefore, this act becomes what you call not representing the feelings of the people who really honor the constitution. So that becomes inconsistent or unconstitutional.
Your Lords, it is to be contended that the feelings of a community comes from historical rights, Your Lords. However, Your Lords, if historical rights
You are
are
a democratic country.
indeed, Your Lords, we are a
What is democracy?
Your Lords,
Majority rules. Democracy is a majority rule,
Indeed, Your Lords.
isn't it?
Indeed, Your Lords.
Even though we call it as by the people, for the people, all sort of things, but it's a majority.
It is the rule of the
Correct.
people, Your Lords.
So then this so-called Aryavada community is a majority community. Why don't you see the feelings of them then?
Your Lords, my same contention is that, Your Lords, this feeling comes from a historical right, Your Lords. And, Your Lords, for the
Historical rights.
historical right as to, Your Lords, that the temple existed in a historical time and another structure was allegedly built over it. It is
Allegedly.
was allegedly built over.
Allegedly.
Indeed, Your Lords,
But
allegedly.
you have scientific proof to say that was built on the other.
Your Lords,
Why do you call it as allegedly? In
Your Lord-
fact, it is existing.
Your Lords,
How come the state, you're representing the state,
Indeed,
how
Your
come the state overruns their own institution? You have ASI. ASI says this was done by them. ASI is a
Indeed.
neutral party.
Indeed, Your Lords.
In fact, the second opinion was given by a person, none other than that belongs to the other community. Isn't it? So,
Your Lords, it should be contended that what your Lordships are saying is that the ASI has already said that a mosque was built over a temple. But, Your Lords, it should be considered that what the ASI has said is pertaining to one particular dispute, Your Lords, and not all the numerous claims which the petitioners are claiming, Your Lords. Hence, Your Lords, when the ASI says that one particular dispute, one particular place of worship is built over another, it is pertaining to only one case and not all the cases, Your Lords. This is the contention of the council.
so how do you answer this question now? How
Pardon?
do you answer this question? There is a violation. You admit there is a violation
Violation of your Lordships?
of their rights.
No, Your Lords.
No.
The council would like to humbly differ with your Lordship's opinion in this regard that there has been no violation of the rights of the petitioners in the current context, Your Lords. As Your Lords, this honorable court has already highlighted, Your Lords, that 15th August 1947 marks a watershed moment to heal the wounds of the past, Your Lords. Hence, Your Lords, with your Lord's permission, the council seeks permission to proceed further. With your Lord's
How that law can be given a retrospective effect?
Your Lords, with regards to
Whether it is a substantive law or not?
your Lordship, with regards to the law, can be given a retrospective
No,
effect
no,
or
what
not?
law can be given a retrospective effect?
Your Lordship, it is contended that the same issue is to be dealt with my co-counsel, which comes under issue number 2 and 4, Your Lords, and my co-counsel shall be addressing the same question, Your Lords.
So it's not your problem, that is his problem.
Your Lords, the issues were divided as issue 1 and 3 and
Okay.
issue 2 and 4, Your Lords.
So you don't want to interfere with your brother.
Your Lordship, retrospective effect and substantive process comes under issue 2 and
No,
4,
no,
Your Lords.
we can accept his argument and we can reject your argument.
Your Lordships, the contention is
Then-
not that
No, no, you are coexisting.
Indeed, Your Lords, we are
Yes,
coexisting.
It is not his problem or your problem. It
Your
is the
Lordship, the-
problem of a respondent.
Your Lordship, the question is not that the problem is mine or him. The question is that the issue is under his ambit. He is dealing with that particular issue. Hence, he is the learned one to deal with that issue and answer this question, Your Lords.
So DNA passes through him according to that it is his issue, that DNA is rest with him, so that's why he has to answer.
Your Lordship, the contention of the council is not this, Your Lords. However, Your Lords,
You
the
are not
council...
acquainted.
Your
You are
Lordship,
not acquainted with that issue.
Your Lordships, the council is not the perfect one to answer that question.
Okay, okay.
Complete
Yes,
knowledge
proceed,
about the
proceed.
issue is with the
Yes, yes, you
co-counsel.
proceed. Yes.
Your Lords, further, my learned counsel raised issue about Section 5 of the Places of Worship Act, Your Lords. Your Lordship, it is to be contended that the exemption carved out for the Suryapuri dispute does not create any arbitrary classification, but rather it reflects on a context-specific legislative wisdom, Your Lords. Your Lordship, it is imperative to view this contention in the light of the case of Hamdard Davakhana. Herein, this honorable court has noted that the legislature is presumed to understand the needs of the people and that the elected representatives enact laws on the rightful understanding of the problems of the society, Your Lords. And the presumption is therefore in the favor of the constitutionality of the statute. This has been held by this honorable court, Your Lords. Furthermore, Your Lords, at the time of the enactment of the Places of Worship Act, the said dispute, which is the Suryapuri dispute, had already acquired a unique national character, Your Lords, with pending proceedings and widespread ramifications. The legislature therefore consciously chose to allow that existing live dispute to reach judicial resolution while simultaneously drawing a line to prevent flooding of similar claims in the future, Your Lords. This legislative wisdom has already been recognized by this honorable court in Mohammed Siddiq, Your Lords. This constitutes a clear, intelligible differencia, that is pre-existing and exceptional dispute versus all future and dormant claim, Your Lords. This bears a direct nexus with the object of ensuring finality and preventing widespread unrest, Your Lords. Furthermore, Your Lords, one contention of my learned counsel that was that a singular dispute cannot be regarded as a classification, Your Lords. However, the council would like to contend, Your Lords, that while the case of Ramakrishna Dalmia, it is noted that even a single instance may be carved out as a classification, Your Lords. Furthermore, Your Lords, the petitioners contend that their right under Article 25 and 26 has been violated. Your Lordships, the council respectfully submits that such a challenge is misconceived, Your Lords,
No,
as it...
classification may be there, but you have to satisfy the second one.
A reasonable nexus, Your Lords.
Yes.
Indeed, Your Lords. For that purpose,
No,
Your Lords,
that is lacking.
Your Lords, for that purpose, for a rational
An
nexus, Your
individual
Lords.
can be a class by himself. That we will admit.
Indeed, Your
But
Lords.
the rationale to be achieved, what is the rationality?
Your Lordship, in
If
the
any one of them fails, that your right is not there.
Your Lordships, in the present case, the Suryapuri dispute clearly constituted such a class given its historical, political and social sensitivity, Your Lords. The councils themselves contend that there were communal unrest before the passing of this act, Your Lords. Hence, Your Lords, to put a rest on these unrests which were particularly linked with Suryapuri dispute, Your Lords. This Suryapuri dispute was carved out as an exception to allow judicial resolution and to make sure public order, Your Lords.
Does the Constitution profess equal rights?
Indeed, Your Lords.
Then how come 91 provides a specific provision for another religion, only one religion?
Your Lordship, it should be understood that when this exemption was carved out, it was not clear in its verdict that this dispute, that this land belonged to the Zaria community or the Paramdharan faith, Your Lords. This decision came out in 2019, Your Lords, when it was proved that this belongs to Paramdharan faith, Your Lords.
Was there an enrichment? Now the problem is I'm using the word carefully. Was there an enrichment by that religion sector out of this act?
Which religion, Your Lords, would be asked by the question?
A religion which has been exempted by this act?
Your Lordships, again the contention would be that when the legislature carved this exemption, they didn't knew that what would be the verdict and if the land surely belonged to the Paramdharan faith. They carved out this exemption.
Sorry. You gave a judgment to your own case now. This act is not a well-considered act. Is that your submission?
No, Your Lords.
So
Your Lords,
then you said they didn't know the consequences of an act.
Your Lords, my contention is not that the legislature didn't know the consequences of the act. The legislature didn't know that whether the Supreme Court would rule the Suryapuri Mandir disputes land in favor of the Paramdharan faith or the Zaria community, Your Lords. This decision came in 2019 and the act was made in 1991, Your Lords. Hence, Your Lords, it cannot be understood that this exemption was carved out for the benefit of Paramdharan faith, Your Lords, as it was not fixed at that time.
Does this act provide a special preference to a sect?
Your Lords, the act
Go
does
through
not.
the act. Does this act mention of one single religion?
No,
Does
Your
this
Lords.
act? Huh?
No, Your
No?
Lords. The Places of Worship Act nowhere mentions a prejudice for one specific community, Your Lords. It is applicable on all the communities equally, Your Lords, be it the Paramdharan faith or the Zaria faith or the Buddhist faith, Your Lords.
This excludes 3. I thought there is an exclusion.
Provision.
There was a proviso. Isn't there an exclusion? Tell me the section. 5.
Exception that was placed for the Suraya Masjid, section 5.
Section 5. That's I went through. That's why I'm wondering suddenly how it disappeared.
Other exceptions are given, section 4, subsection 3, Your Lordship.
Correct.
For proviso.
Yes.
And the 5 is the exemption.
So, does it exclude a religion?
Your Lordships, the content.
No. My question is direct. Does this act excludes a religion when
No,
it
Your
was
Lords.
passed?
No, Your Lords.
No.
The act exempts a particular dispute which was in dispute at that time, that whether it belonged to Paramdharan faith or it belonged to the Zarian faith. It wasn't clear at that time that it belongs to a Zarian faith or it belongs to the Paramdharan faith. Your Lords. Hence, it cannot be said that it carved out for a specific community, Your Lords. It was a dispute back then, not a verdict, Your Lords. That is the humble contention of the council, Your Lords.
Correct.
Your Lordships, further, with regards to the contention that it is violative of Article 25 and 26, Your Lords, it is respectfully submitted, Your Lords, that what is protected under Article 25 and 26, Your Lords, is the essential religious practices of a particular faith, Your Lords. This Honorable Court has already noted that Article 25 and 26 only protect those practices of a particular religion which are the essential religious practices, Your Lords. Now, Your Lords, the question would be that what is an essential religious practice and what is not. For this purpose, Your Lord, this Honorable Court has laid a test to determine as to what is an ERP and what is not. For this purpose, Your Lords, on flag number 14, we have the decision of this Honorable Court wherein this court has noted that a religious practice would only be termed as an essential religious practice if the restriction of it would result in the fundamental change in the character of the religion, Your Lords. However, applying this test, Your Lords, the petitioner's sweeping claim to worship at numerous historical sites which has not been exercised for centuries and whose absence has particularly not altered the core identity of the Paramdharan faith, these practices cannot be said to constitute a part of the essential religious practice, Your Lords. Furthermore, Your Lords, the Learned Counsel placed reliance of the case of Ismail Farooqi, Your Lords. However, Your Lords, in Ismail Farooqi, Your Lords, this Honorable Court noted that while offering of prayer is a religious practice, Your Lords, its performance at every possible location is not an essential part or integral part of the religion, Your Lords. When the Learned Counsel says that the temples are of particular significance, your lords, they themselves contradict their own point wherein they say that Kashi, Mathura and Ram Janmabhoomi are of particular significance. However, your lords, they also contend that numerous temples should be claimed under the essential religious practice, your lords. And for the same purpose, your lords, section 5 was carved out as it was for a particular significance for both the communities, your lords. Furthermore, your lords, with your lordship's due permission, the council seeks extension of time, your lords. Your lordship, it should be understood that the
2 minutes. 2 minutes.
Your lordship, the council would sum up the first issue in 2 minutes and then would move on the third issue, your lords.
So how long do you want?
Your lords, my first issue is...
How long do you want?
Your lords, the council seeks an extension of 10 minutes at least, your lords.
No, you're
Your
going
lords, the
out.
council...
5 minutes.
Your lords, the
Your time
content...
it.
Your lords,
5 minutes extra we will give
Your
you.
Lord-
Within that you have to conclude.
Your lords, the contention of my learned counsel was that since a temple was existing in the historical time, the same right exists today to reclaim that temple. However, your lord, this honorable court in Mohammed Siddiqui has clearly laid down the doctrine of continuity, your lords. If your lordship may please refer to flag number 8 of the compendium. This honorable court in Mohammed Siddiqui has noted that the courts cannot today take cognizance of historical rights and wrongs unless it is shown that their legal consequences are enforceable in the present, your lords. The legal consequences of actions taken or injuries suffered in previous legal regimes, which was the Zarian regime, can only be enforced by the court if they received implied or express recognition by subsequent sovereign, your lords. However, for this purpose, this honorable court also went further to record that for this submission to be accepted, it would need to be demonstrated that every subsequent sovereign to the territory within which the disputed land forms either expressly or impliedly recognize the legal right of the plaintiff, your lords. However, your lords, in the present case, the petitioner's own narrative indicates that for prolonged period across regimes in the past, the claimed right was neither effectively exercised nor it was shown to have been recognized by the Zaria rulers, your lords. Hence, your lords, by going by the doctrine of continuity as established by this honorable court, if the same right was not recognized by every subsequent sovereign, which particularly includes the Zarian ruler, your lords, the right to reclaim a historical site cannot be sustained in the present time, your lords. Furthermore, your lords, the honorable court has also noted that the mere existence of a structure underneath the disputed property cannot lead to a legally enforceable claim to title today. Furthermore, your lords, with pertaining to issue number 3, your lords, the council would like to humbly contend that if your lords may please refer to flag number 8 of the compendium, the honorable court has noted that the law cannot be used as a medium to reach back in time and provide a legal remedy to a person who disagrees with the course with which it has taken, your lords. The honorable court further noted that the republic consciously departed from resolving claims on the basis of religion, ideology or historical origin and instead frame all its rights within the framework of the rule of law, and this rule of law includes the doctrine of continuity, your lords, which has not been sustained in this present case, your lords. Furthermore, your lords, the Honorable Supreme Court in Mohammed Siddiqui noted that while disputes concerning religious sites often involve references to history, archaeology and religion, the law must stand apart from the ideological contestation over the past, your lords. The last contention of the council would be, your lords, that the right of the petitioners is only based on a historical right, your lords, which is that a temple existed in the medieval era and hence it is enforceable today even if it is broken. However, your lords, applying the doctrine of continuity, it is to be proved, the burden of proof rests on the plaintiff to establish that every subsequent sovereign that came after the temple was built has recognized the same legal right of the plaintiffs, which the Zaria community came after the temple was built did not recognize the right of the Zarian community, your lords. However, your lords, if the burden of proof here for the same is not established, the same right about historical right, your lords, cannot be enforced in the present case, your lords. If your lordships are satisfied with the contentions made by the council with regards to issue 1 and 3, the council seeks permission
So, what is the option for the petitioners to seek legal address for their alleged historical wrongs?
your lords, the option for the petitioners to seek,
Can you curtail their rights in such a manner?
your lords, it should be understood that those rights can be curtailed, which right exists, your lords. However, your lords, the right to enforce a historical right, the right to enforce a historical claim is not even existing years. As your lords, the subsequent sovereign Zaria rule did not recognize the right of the petitioner, your lords. Hence, your lordship, by going by the doctrine of continuity, the same cannot be enforceable in the current sovereign, your lords. An alternative option for the petitioners would be that to establish that every subsequent sovereign which came after the temple was built did recognize their right to claim their historical temples, your lords. If this burden of proof is been established, then, your lords, it may be said that the right exists
Where,
for the.
where they have to establish?
Indeed, your
You
lords,
have
that is my point.
No,
They
no,
have.
you have prohibited it, that filing a petition itself. That is taken out the jurisdiction of the courts.
Your lordship, it is to
Where
be.
they have to establish.
Your
That
lordship,
is the moot question.
your lordship, it is to be contended that this honorable
No,
court in
no,
Mohammed.
if you could have given some forum, so then they could have adjudicated. So if you close all the doors and say, no, that you are having breathing,
So is total prohibition permitted?
Your lords, it should be considered that this honorable court in Mohammed Siddiqui also noted that
Yes.
the moment the plaintiff asserts the claim of historical right, from that moment onwards the burden lies on the plaintiff. In this present hearing, your lords, the petitioners mentioned that they have a historical right to reclaim the temple which was there in medieval era. Hence, your lords, from that moment only the burden of proof rested on the petitioners to claim and then further explain as to the doctrine of.
Before which forum?
In this present hearing itself, your lords, they contended herein itself, and herein itself the very moment they.
So you admit our jurisdiction.
Your lords,
You admit our jurisdiction.
indeed, your lords. Your lords, the last contention would be that in the case of Mohammed
so
Siddiq.
if you admit this, one more issue will be there, or one more question will be there.
Your lordships,
So if all the persons in the country, they approach this particular court, so this court has to only decide religious rights.
your lordships,
So no other work will be there to this court. Yeah.
your lordships. The contention of the council is not that
No,
all
no, no. If you admit the jurisdiction of this court, then you have to give right to agitate before the trial court first.
your lordship.
No, no. If you admit the jurisdiction of this court, that you have to, that is allowed
Your
to
lordship.
adjudicate in the trial court.
Your
This court cannot be a trial court to
Indeed.
sit and decide
Indeed, your
the
lords.
rights of each individual.
Indeed, your lords.
Yes.
Your lords, but there is a material distinction which would further be elaborated by my co-counsel between judicial review and judicial remedy, your lords. This particular case herein is a question of judicial review, your lords, which pertains to the constitutional validity of the act. However, your lords, for judicial remedy, the petitioners have to go to a civil court. Your lord.
That's not there. Because there is no remedy, they are seeking the relief
Indeed, your
or
lords.
review.
Your lordships, as already elaborated by the council, with deeper knowledge regarding to judicial review and judicial remedy is specifically pertaining in the issue number 2, which is Article 32 and 226, and the same is not to be dealt by the current
You
council.
wrap up your answer. Next question, next council can answer the next one.
Yes,
You
your
have
lordship.
shifted the burden on him now.
Your lordships, the questions which are the two questions which were asked to the current council did not belong to issue number 1 and 3, your lords. Their answer are available in issue number 2 and 4, your lords. Hence, for the same purpose, the council is relying on my co-counsel.
Yes.
If your lordships
You ask
permit,
your co-counsel to argue that. Okay.
if your lordships permit, the council
Yes.
seeks permission to invite my co-counsel.
Yes.
Much obliged, your lords.
Your burden is on a higher pedestal now.
Your Lords,
Carry on, carry on.
firstly, Your Lords, there were some assertions made by this honorable bench pertaining to when the learned counsel for the petitioner were arguing for their side. We would like to highlight those points also. Firstly, on the assertion of this honorable bench as to what were the learned petitioners doing from 1991 to 2026, to which the learned counsel for the petitioner replied that the suits were barred. Your Lords, it is humbly contended that the doctrine of judicial review mentioned under Article 13 of Constitution of Aryavata were never barred. The learned counsel for the petitioners have moved a writ petition in 2026 as well, challenging the constitutional validity of the Act. It is humbly placed, Your Lord, that challenging this Act was never barred. Judicial review enshrined under Article 13.
Get little away from the mic. No, little away from the mic. Don't get close to it. They will pick it up.
Apologies. It is humbly contended that challenging this Act was never barred, which is enshrined under Article 13 of the Constitution of Aryavata, which is judicial remedy. There persists a difference, a thin difference, Your Lords, but
Get little away from the mic. Just speak from the place you are. Don't get close to the mic.
apologies.
They are finding it difficult.
Apologies, Your Lords. So it is humbly submitted that there is a thin line between Article 13 and Article 32 of the Constitution of Aryavata, Your Lords. Secondly, it has been rightly pointed out by Your Lords.
What is Section 5?
Your Lords,
What is Section 5 in this Act?
Your Lords, it is pertaining to the exceptions given to the dispute.
Why?
Your Lords,
Why?
Your Lord, because the particular dispute which was
There was a dispute.
yes, Your Lords, dispute.
So you recognize there is a dispute in hand,
yes, Your Lord, it was
Correct.
a dispute. Yes, Your Lords.
right?
Yes, Your Lords.
So you excluded that.
Yes,
So,
Your Lords. The dispute was
Have you all
excluded.
made a omnibus clause or a provision in the Act for a similar dispute currently or in the future?
No, Your Lords.
No.
No, Your Lords.
So it's not a well-considered Act.
No, Your Lords. We would humbly like to differ from this opinion, Your Lords. The particular,
Even in 1991, there was a dispute. This dispute is before that, correct?
Your
When you
Lords.
passed the Act in 1991, the dispute was there.
Your Lords,
When was the judgment came?
Your Lord, it came way after 1991 into
So-
2023, Your Lords.
So whom to be blamed? For us to be blamed?
Of course not, Your Lords.
It is.
The judiciary is never to be blamed for the issues.
Yeah, it is us to be blamed
You know,
because we delayed. We should have given.
Your Lords, the council here would humbly contend that this particular act, which is the Places of Worship Act 1991, was brought in the light of the communal riots. It is to be marked that the Babri Masjid, the demolition of Babri Masjid, was in the year of 1990, Your Lords. Seeing all these communal riots which were persistent in the country of Aryavata, it was mandated or it was suggested by the
Other
parliament.
criminal laws are there to curtail that all that is criminal rights and other that if any that is violation is there. So other laws are there. Why that you pass this law?
It is, of course, there persist other laws for that perspective,
No,
Your
whether
Lords.
they are ineffective
No, Your
according
Lords.
to your own view.
No, Your Lords.
Then
It is.
Other laws are very much available.
Of-
So you can prosecute them there.
Of course, Your Lords. However, this council here is contending that
You
the
high-handedly passed this act.
Your Lords, it is humbly contended that there persist many other laws pertaining to maintainability of public order, health and morality, Your Lords.
Yes.
However, to this particular aspect of conversion of religious sites, Your Lords, it is a very sensitive topic. Your Lords, the fact sheet itself states that there were plenty of losses of life. There was a mass destruction, Your Lords. The Babri Masjid was also demolished.
Do you support the Act with your Hansard?
Your Lords?
Do you support with the parliamentary record of Hansard?
No, Your Lords.
No.
No, Your
Do you
Lords.
know what happened at the time of passing this Act?
Your
No.
Lords.
Do you have any historical study? No. So it's only the paper value that you're talking now.
Not, it is not, of course, it's not the paper value, of course, Your Lords. It has to be taken on record by this judiciary also. which is enshrined under the exceptions which is given in the Constitution of Aryavat pertaining to the public order, health and morality, your lords. It is a humble summation that this honorable bench or the Supreme Court or the High Court for that matter, your lords, are having the jurisdiction to adjudicate the matters pertaining to your lords public order, health and morality. However, reasonable restrictions as proposed by my co-counsel could be made regarding this public order, health and morality by the legislature itself, your lords. This is the only humble contention which the council is making currently.
No, you could have given that particular reasonable, how that it comes under reasonable restrictions.
That has already been explained by my co-counsel, that a rational nexus and an intelligible differentia has been established by this council pertaining to the matter of conversion and pertaining to the matter of specifying a cut-off date, which is 15 August 1947, your lords. Your lords, it has been rightly pointed out by your lords while referring to Article 32, Subclause 1, read with Subclause 4 of Constitution of Aryavat, that the Learned Council had gone through a subsequent period of time lapse, and nowhere the rights pertaining to the same was extinguished by that time lapse, your lords. It was from the side of the Learned Council, by virtue of which the doctrine of vigilantibus non dormantibus non excusat, meaning sleeping over one's own right, would have had a consequence on them, your lords.
Is it not a colorable legislation?
Your lords?
Is it not a colorable legislation?
No, your lords, it's actually not a colorable legislation, your lords. The exceptions that have been carved out were pertaining to their specific
which
reasons.
you cannot directly do. So here, by virtue of this act, you are doing it. That is a colorable legislation.
Correct, your lords. However, the council here would contend that the specific things which might affect or might attract the doctrine of colorable legislation in this particular scenario would be section 5, of course, your lords. Why were the dispute, as multiple times asked by this honorable court to the council, your lords, and the reasoning of the same was given to this honorable court, that many instances were persistent regarding to the communal riots, disharmony, public order and peace. Your lords, there persisted subsequent laws pertaining to regulating the public order, health and morality, your lords. However, those particular laws did not actually or specifically address the public order, harmony or disrest proposed or influenced by the conversion of religious characters, your lords. And that is the same the council here is merely contending, your lords. Moreover, one simple thing to point out here is, your lords, it is humbly contended that the laws here are perimaterial and not the facts. Hence, the fact sheet of this particular preposition says that the laws are perimaterial and not the facts are perimaterial, lords. A reference can be drawn. However, we cannot state a particular date is a current date, particularly to the Suryapuri Mandir dispute, your lords. Facts are not perimaterial. Laws are perimaterial in the fact sheets. There lies a distinction between this concept of perimateriality of laws and facts as well, your lords. Your lords, it is also asserted that mosques or temple, for any instance, any other religious places as well, be looked upon by the government for regulation. It was a suggestion made by the Honorable Court, your lords. This suggestion, any case instituted before or on its commencement, and in doing so sets forth 15 August 1947 as a cutoff date. This, your lord, must be perceived after hearing or after reading the whole provision thereof. Your lords, in the same provision of the act, it is also stated that any conversion after the cutoff date is open to judicial scrutiny. First thing, your lords. In addition to this, the act recognizes the heritage site mentioned under the official gazette as notified under the Ancient Monument and Archaeological Sites and Remains Act to be open to judicial scrutiny. Second, henceforth, the council here is merely contending that the act does not completely bars or put a blanket prohibition on the suits, your lords. It puts a reasonable positive restriction to maintain public order and harmony. Your lords, the council is not of the contention that the profession of one's own religion should not be allowed. However, your lords, the same is subjected to certain exceptions which is mandated by the constitution itself. And those particular exceptions can be seen from Article 25 of the constitution, your lords. The article starts with the phrase subjected to public order, health and morality, your lords. These exceptions, your lords, public order, health and morality. On the same note, your lords, the impugned act without any classification maintains these essentials as mandated under the Constitution of India, your lords, Constitution of Aryavat, your lords. Your lords, by virtue of this assertion, the council here is merely contending that the Places of Worship Act do not bar each and every suit pertaining to conversion of religious character, however restricts only those suits which are instituted deliberately to stir up a frivolous litigation, overburdening this court with unnecessary suits, your lords. Your lords,
Mr. Counsel,
your lords.
you read the preamble, the word secular has been used.
Your lords, correct, your lords.
And then that is section 5. How that you justify it?
Your lords, again coming to that particular instance, your lords.
No, that you are taking a particular.
Yes, your lords. Section 5 of this Places of Worship Act again is carved out for only one purpose, your lord. There were many other instances as well where other there were other sides at disputes, your lords.
No, I am that is concentrating. That you know, basic structure principle.
Your lords, your lords.
So here, secular is a basic structure.
Your lords.
So
Correct,
here
your lords.
you are affecting that basic structure, secular.
Your lords, it must be,
In
is
many
humbly,
cases, even you take Keshwananda Bharti and other, all the cases, that what they say. Even you can amend the constitution except the basic structure. No, by virtue of this act that you are going to, that is, affect the basic structure itself.
your lords, the council here would humbly submit a different opinion here, your lords. Reason being, your lords. Firstly, the word secular.
How that you are showing your secularity?
Yes, your lord.
No, state has to show your secularity.
Yes, your lords.
So how that you justify it?
Your lords, the exceptions. Firstly, the reasoning of the exceptions, your lords. The exceptions was carved
No,
out.
you cannot go to the Article 14 and the classification. And no, but you have to satisfy the preamble itself.
Correct, your lords, correct.
Then,
Coming to that part only, your lords, we would humbly like to contend that both the concept of public order, harmony and peace and the concept of secularism are mentioned under the Constitution of Aryavat. Both must be looked upon, your lords. Reason being, your lords, being a secular state, it is also the duty or responsibility of
separate it and
Of,
the rule.
No,
You
Your
are
Lords.
doing that.
It is the duty of the legislature to maintain public order, harmony, and etc. Your Lords. Your Lords, I would humbly like to contend that the Indian brand of secularism is not complete divorce between a church and a state, Your Lords. It is interference, Your Lords. It is not no interference. It is interference, Your Lord, but subjected to non-discrimination, Your Lords. This is the Indian brand of secularism, Your Lords. The concept of secularism, Your Lords, and the concept of public order, health and morality, both should be dealt by the legislature also, Your Lords. So if secularism is to be seen and public order and health and morality should be ignored, that would also be not correct, Your Lords. Secondly, if public order and health and morality should alone be seen and secularism should be avoided, Your Lords, it would also be, Your Lords, it would also be not idealistic or practical, Your Lords. However, coming to the pragmatic aspects, Your Lord, there is no particular section which directly say that this so and so particular community should be treated differently. Your Lords, there is a dispute where public order harmony is very much in question, Your Lords. That must also be addressed.
Your
Public order-
co-counsel only told that the court can infer.
Your Lords,
Court can infer. That's what he also argued.
infer what, Your Lords?
Yes, with regarding to all these aspects, that what the legislatures are intending and all these things that he was arguing. Yes.
Indeed, Your Lord, the judiciary is can see to the underlying presumption. Of course, that is the matter, but that underlying presumption should be seen positively and not negatively. This particular section was never brought for a particular political purpose, Your Lords. It was only for the matter or for the purpose of securing religious characters, first thing. Second, maintain public order and harmony, Your Lords. Nothing else.
Does it benefit a certain sector? Does this act benefit to a certain sector?
Your Lords. Your Lords, in my limited...
Can I have a yes or no answer? Can I have a yes or no
Yes,
answer?
in my limited opinion, no, Your Lords.
But your co-counsel admitted there is.
There is what, Your Lords?
Would have followed it.
No, Your Lords.
This act supports a certain sector, or this act
Your Lord,
this
I would
act brings certain loss to a certain sector. Either way.
It is humbly contended that my co-counsel never admitted to this fact or this particular instance, Your Lord. He was of the opinion, or he stated that that particular dispute, which was mandated under Section 5, was mandatory because of so and so reason, which we have just made, Your Lord, and nothing else, Your Lord. We have not stated, or we have not asserted or attested the fact that the particular places of worship act differentiate between communities and religions, Your Lords. Nothing else. It is humbly submitted that an extension must be given, Your Lord, might be given, Your Lords. Extension, Your Lord. Extension of time, Your Lords.
How long?
Your Lords, I am currently on my second issue only, so if it may be deemed fit, then approximately 7-8 minutes, Your Lords.
5 minutes is given. 5 minutes you conclude. Yes.
Maximum.
Indeed, Your Lords, I would try to wrap this up, Your Lords. By virtue of these assertions, supporting assertion mentioned under these arguments, Your Lord, it would be appropriate to visualize the issue as present-day harmony, peace and morality versus historical wrongdoings, Your Lords. Your Lords, historical pretext should not be generalized to an extent where the minority's interest is prejudiced. Your Lords, under Article 29 of Constitution of Aryavard guarantees, Your Lords, Article 29 of Constitution of Aryavard guarantees certain interests of minority as a fundamental right. These concepts, Your Lords, was when stacked together, do not in any way suggest that a right under Article 32 and 226 for that matter, which is judicial remedy, has been infringed. Rather, it poses a rational idea of prevention. Your Lords.
I was expecting this in the beginning, but you came straight into the death pit or the grave. Whom are you claiming as minority?
Your Lords.
Whom are you claiming as a minority?
Your Lords, because of the Paramdhara being an indigenous community of Aryavard, Your Lords, as stated in the fact sheet, Your Lords, not directly, Your Lords.
No. Can you answer the question?
I'm coming to
Who is
that.
the minority?
My humble submission
the
would be
petitioner?
the Zaria community, Your Lords. The Zaria community is the minority here, Your Lords.
You're firm on that.
Yes, Your Lords.
Proceed now.
Rather, Your Lords, it poses a rational idea of prevention of unrest among the citizens of Aryavard, Your Lords. Your Lords, coming to the fourth issue, whether the impugned...
That's 1991 Act
Yes.
protects the minority or protects the majority.
Can you please pardon, Your Lords?
Does 1991 Act
Your Lords,
protects the minority or protects the majority?
it protects all, Your Lords.
All.
Yes, Your Lords. No specific community, neither Zaria community per
By
se,
giving a date,
Your Lords,
by giving a date of arbitrary date given,
Your Lords, as contended by my co-counsel as well, that there might be certain places which tomorrow Buddhist community can claim that beneath that temples are tombs, Your Lords. It is imperative to
Refer
know.
to any particular.
Indeed, Your Lords. Apologies for the same, Your Lords. However, this particular date has been mandated because, first, Your Lords, overburdening of the cases. If we go so far back, there would be many instances, Your Lords, referring to the colonial period mentioned under the fact sheet, Your Lords. There might be some churches, Your Lords, as well. We cannot particularly say, or we cannot particularly go date back 400, 500 years for an example, and pick that dispute up in present day, Your Lords, that this particular site was converted 400, 500 year back, Your Lords. Again, Your Lords, coming to that particular thing.
but your state
Yeah, Your Lords.
relies on the history because the Aryavada community lives in history.
Your Lords.
The breath,
Of course, Your Lords.
or they breathe with the history civilization.
Correct.
So how do you say you're not relying on the history?
Correct, Your Lords. Even presuming that, Your Lords, that we are relying on the historical parts and the rights are, the Paramdhara community rights are being derived from that historical pretext or historical things, Your Lord, there subsist limitations to that particular thing. Your Lords, after 400, 500 years, Your Lords, you are coming to this particular court and you are mentioning that so and so particular parcel of land having temple and having land were converted, dated back to the 400, 500 years, Your Lords. These particular parcel of land on which a temple, for example, has been made, Your Lord, these particular temples, even after demolition, Your Lords, presuming even after demolition, Your Lords, are subjected to certain limitation mentioned under the Limitation Act as well, Your Lords. And that must also be seen by this honorable courts, Your Lord. Just an assertion, Your Lord, nothing else. Moving on, Your Lords. The council most respectfully submits that the issue is the issue number 4. Your Lords, extension. It is humbly pleaded, Your Lords. It is begged.
2 minutes last.
Okay, Your
We'll
Lords.
wrap up.
Your Lords, secularism in Aryavat, as affirmed by the Constituent Assembly in para 5 for the moot preposition, is not the denial of religion but a positive constitutional commitment to harmony, tolerance, and equal respect of each and every faith. It is given under the preposition only, para 5, Your Lords. It requires the state to maintain neutrality and prevent any other community from reopening ancient historical disputes in a manner that disturbs public order and harmony. The Act achieves precisely this by mandating that religious character of places of worship shall remain as it existed on 15th August 1947, the date Aryavat emerged as a sovereign democratic republic, Your Lords. Your Lords, the petitioner's real or presumed grievance is that pre-independence historical claims are being shut out. With utmost respect, the council submits that secularism under constitution cannot be converted into a perpetual license to litigate medieval or colonial era grievances, Your Lords. Allowing such a claim would itself destroy the secularism by dragging the nation back into the religious conflict of the past and by compelling court to sit in a judgment over disputed pasts. Your Lords, the petitioners complained that the Act prevents redressal of historical wrongdoing, misses the constitutional points. Secularism under our constitution cannot be interpreted to mean that the court must sit in a perpetual judgment over events that occurred centuries back. When Aryavat was even not a democratic republic, sovereign democratic republic, Your Lords. Such an approach would itself destroy secularism by reopening medieval and colonial era conflicts and forcing the judiciary to adjudicate dispute historically, Your Lords. This is my wrap-up, Your Lords. I would now like to move on to the prayers, Your Lords. Wherefore, in the light of the issue raised, argument advanced, and authorities cited, submission made hereto above and those to be urged at the time of the hearing, the respondent humbly prays that this Honorable Supreme Court may be pleased to 1. Dismiss the writ petition along with all connected matters in their entirety. 2. Uphold the constitutional validity of Section 2, 3, and 4 of Places of Worship Act 1991 and or pass any other order, direction, or relief that may be deemed fit in the interest of justice, equity, and good conscience. And for the act of this kindness, the respondent shall be bound forever.
No extension will be granted.
Your Lordships, 2 minutes of the time.
All your times, you have to stick to your time, including the questions.
Your Lordships, firstly, I would like to apologize if I will not be able to cite any of the cases that the respondents have used because we did not have access to the same, nor were they stated by name by the respondents. Your Lordships, firstly, we are not challenging the fact that the respondents have the right to set a fixed date or the right to carve out an exemption. We are pointing out the fact that this fixed date and the exemption are arbitrary in nature. Your Lordships, the fixed date, first of all, no public inquiry was held to ask the people if they agree to the fixed date, even after seeing the dissent that was caused due to the date. Additionally, Your Lordships, they have not been able to prove why 15th August 1947 was chosen, as it does not have any religious significance to either communities or any religious community in this country. Additionally, Your Lordships, the exemption was also not proved, as they themselves stated that only the law is paramateria to the law of India. Your Lordships, nowhere in the facts is it stated that the Suraiya Masjid was destroyed in 1991. So how can they say that it was the destruction of the masjid that caused it to be added as an exemption when it was not a fact at all stated? And if that is not the reason for it to be an exemption, what is the reason? Additionally, Your Lordships, another thing that comes up is, Your Lordships, Suraiya Masjid was not the only disputed site or not the only site that had communal riots being seen across the nation. As I have stated, Kashi Vishwanath and even Krishna Janmabhoomi were two other disputed sites which had seen communal unrest being formed. They were not added as exceptions. This proves that there was no rational nexus behind the Suraiya Masjid being given exemption. Additionally, Your Lordships, they themselves stated that it was because of the communal riots that Suraiya Masjid was given exemption. Your Lordship, does that imply that if communal riots are caused, the disputed side will be added as an exemption to the act, even in the future? And that if that is not the case, then why were the communal riots of that time enough for the Suraiya Masjid to be considered an exemption? Your Lordship, moving forward, another rebuttal I would like to point out is that they stated that historical evidence will not be accepted. Additionally, they also stated that these are frivolous claims and that the court should not be burdened by them. Your Lordships, these are legitimate claims that the people of Paramdhara have been trying to portray with historical evidence supported even by the ASI, as even the bench mentioned. Your Lordships, they cannot claim them to be frivolous. Another thing, Your Lordship, they pointed out was that the court should not be overburdened by these cases. Your Lordships, when the court is overburdened, the cases are shifted to either the jurisdiction of another court or a tribunal is set up to hear the same. Your Lordship, nothing of the same has been done here. They have been prohibited. The people have been prohibited from coming and having the cases heard fully. That is not reasonable, Your Lordship, and it is, again, not falling under the reasonable restrictions set even under Article 25. Additionally, Your Lordships, they stated that historical rights must be accepted throughout history and even in Aryavatha. Your Lordships, the concept of rights was not even a possibility during the Mughal rule. And even under the colonial rule, our rights were determined by the people of Britain. They were not determined by our needs and necessities. And even then, Your Lordships, personal laws were left untouched. And even today, personal laws, while they have been put under reasonable restrictions, Your Lordships, prohibition of hearing cases about personal laws is not reasonable. Or a restriction, it is prohibition. There is a difference between both the words, Your Lordships. Your Lordships, another thing that they have pointed out is that we are, first of all, Your Lordships, we are not claiming we are here because of a historical right. We are claiming that we are here because of a historical injustice. There is a difference in between those things. We had a right to profess our religion that was taken away from us. We are contending that fact here, Your Lordship. Additionally, Your Lordships, as they themselves stated and as it is written in the Act, that conversions that occur after 1947 shall be adjudicatable. Your Lordship, will that not cause public unrest? As it is still a sensitive matter about places of worship about 2 to 3 religions. Your Lordship, will one party not come out as the victor and one party not the defeated? And will that not cause public disharmony? Why is it that only the disharmony caused due to sites that were converted prior to independence is considered to be disharmony and not the ones that might occur now? Additionally, Your Lordships, even after the 2019 judgment, there was disharmony, but it was caroled and controlled. If it could be done then, why could it not be done in the 1990s, and why did this act have to come into picture? Your Lordships, another thing I would like to point out is, Your Lordships, that the section 4.2 of the Act prohibits other existing litigations. It abates all the litigations that might have been filed in any of the courts of Aryavatha. Your Lordship, why was it that only the Suraiya Masjid litigation, which had been filed prior, was allowed to continue while other litigations were stopped, even if they were filed before the Act came into picture? And if that is the reason why, where is the rational nexus behind the same? Your Lordships, if you would just give me 2 minutes to conclude. Much obliged, Your Lordships.
The time already started.
May it please your lordship, the council seeks permission to oppose the dais.
No, you cannot reply. Reply to reply. There is no procedure.
Your Lordship, for the
Petitioner will be having a right to reply.
Your Lordship's re-rebuttal is being a part of this moot court competition, Your Lords, from since the first round, Your Lords. Your Lordship, it is contended that the Act does not apply to all, and the same contention has been made by the learned counsel. However, Your Lords, it should be understood that nowhere in the Places of Worship Act it is stated that this Act only applies to one community or does not apply to one community. It should be understood that this Places of Worship Act, Your Lords, applies to all the community, Your Lords. Even before pre-97, Your Lords, even if a religious site of the Zaria community was destroyed and a Paramdharan temple was built over the same, Your Lords, the same Zaria community too, Your Lords, cannot approach the courts via the Places of Worship Act, Your Lords, as it applies to all the faith and not only on the Paramdharan faith, Your Lords. Furthermore, Your Lords, with regards to Section 5, the learned counsel's contention is that why only Suryapuri Mandir dispute was carved out, Your Lords. However, Your Lords, it should be understood by the petitioner's own claim, Your Lords. They claim that under Ismail Faruqi, those religious shrines which are of particular significance of that faith should be considered. However, Your Lords, here in this case, the Suryapuri Mandir dispute or the Surhaya Masjid dispute, the site which was there, it was of particular significance for the Paramdharan faith and the Zaria faith, Your Lords. Hence, the same was carved out for particular significance, Your Lords. And furthermore, Your Lords, with regards to the question of Your Lordships, it is to be contended that while passing of the Places of Worship Act, the legislature didn't knew in its finality that this land belongs to the Paramdharan faith or this land belongs to the Zarian faith, Your Lords. When this act was passed, the land was in dispute. Hence, Your Lords, it cannot be considered that this particular exception was carved out for a particular sect, Your Lords. Furthermore, Your Lords, my learned counsel referred to a contention, your Lords, that for the Zarian community, for a Places of Worship to exist, it should be done on a pure land, Your Lords. However, Your Lords, with the sheet passed to Your Lords, the same contention was made by an advocate in Muhammad Siddiqui's case, Your Lords, wherein he contended that if a mosque according to Zaria faith is not made according to the tenets of Islam, the same mosque will not be a pure mosque and will not be considered as a valid mosque in Islam. However, Your Lords, the court there held that it is inappropriate for the court to enter upon an area of theology and to assume the role of an religious interpreter or of the hadith, Your Lords. The true test is whether those who believe and worship have a faith in the religious efficacy of the place where they pray or not. It would be preposterous or wrong for this court to question it on the ground that a true Muslim would not offer prayer in a place which does not meet on an extreme interpretation of doctrine selectively advanced by the learned counsel, Your Lords. This honorable court held the same, Your Lords. Furthermore, Your Lords, this final argument would be that only those rights which pertain to history are enforceable in the current sovereign or in the current context, Your Lords, which have been recognized by every subsequent sovereign, Your Lords. With regards to feeling, with regards to temple, with regards to claim, Your Lords, all of the claims are stemming from a temple that existed in a historical time, Your Lords. If that temple existed in an historical time, and if a mosque is built over it, even to assume that if a mosque was built over it by breaking the temple, the same right to reclaim that temple should have been recognized by every subsequent sovereign, and the same is not being done here. Here, Your Lordship, doctrine of continuity is not an exception, Your Lords. It is a mandate, and this doctrine was the ratio decidendi by this honorable court in Muhammad Siddiq, Your Lords. It does not hold a persuasive value, it has a binding value, Your Lords. However, hence, Your Lords, when a claim is made that because a temple existed in the medieval era and it was destroyed and a mosque was built over it, the same right exists today to reclaim it. It should be understood, Your Lord, that within the 500 years, 3 or 4 sovereigns, whosoever came, be it the Zaria faith, be it the Assyrian faith, did they recognize the right of the claimants? No, Your Lords. This is a mandatory doctrine which should be binding on the court. This burden of proof has not been established, Your Lords. The council rests its rebuttal here, Your Lords. Much obliged, Your Lords.
That's all? Yeah, we reserve the judgment.
Deep. Make it out. हाँ. They'll come back as valedictory guests only. They won't come back for judgment. Score sheet. Dear students, kindly note that we will be starting the valedictory ceremony in another half an hour. We will be starting exactly at 3:30, so I request all the students and the participants to be present in the auditorium at 3:30.